Good afternoon, everyone, and welcome to today's webinar on projects arbitration in Romania and Moldova. My name is Matei Purice, and I'm a senior lawyer in the International Arbitration Group of Freshfields, specialized in global projects disputes, both commercial and under international investment protection treaties. I am a Romanian national with strong Moldovan roots, so it is my pleasure to introduce and moderate today's discussions. So just to start, what is projects arbitration? Essentially, it is an area of practice that focuses on disputes arising out of major projects, including infrastructure, energy, oil and gas, mining, as well as general construction projects, including buildings or wider urban developments. It is one of the areas that our international arbitration team at Freshfields focuses on globally. So why this particular topic today? I think there are perhaps three main reasons. First, and I don't like to start with a negative one, but as you may perhaps expect, the first one is linked to the impact of the COVID-19 pandemic on the construction sector widely in the world. It is an unfortunate reality that the pandemic hit the construction and infrastructure sectors at a time when, in several markets, they were already economically strained. We have seen rather in the past year a number of projects either suspended or cancelled for lack of financing, difficulties in the supply chain, or workforce issues, as well as a number of well-established global contractors defaulting on their payment obligations or loans. This trend suggests a gloomy year ahead, but we expect to see an increase in the number of disputes arising out of projects affected by the global pandemic across the world. Now, moving to a more positive reason, which is linked to the significant effort worldwide towards energy transition and the expectation there that the construction sector will be a key one in delivering that transition and taking economies across the world out of the current slump. Finally, a welcome change in the growth of the construction sector, particularly in Romania. And on that, you will see on the first slide one reality, if I can call it that happened in the last year. While at the European Union level, the construction sector recorded a negative growth rate compared to 2019, Romania championed with the most significant positive growth rate across Europe and one of the only three countries in the European Union with a positive growth rate. And so that is an impressive result. And you can see here on this slide a few numbers and trends for the Romanian market. And what I thought was interesting to see is the index index for the construction works in Romania last year. And you can see there an interesting change in that there is a decrease in the number of general maintenance works and capital repairs, but there is a considerable increase in the for new construction projects. And we think that is consistent with the wider efforts at state level to push for major infrastructure projects across the country, especially in the roads and rail sector, as well as in the energy sector. And the registered growth that we've seen, coupled with the fact that the World Bank included Romania among the high-income countries for the first time last year, suggests that the trend is likely to continue. Now, in Moldova, we think that there is a similar trend, and we have seen broad initiatives at state level to modernize particularly the road and rail national networks, as well as the national airport infrastructure in the country. So against that background, and apologies, I was hoping not to have to deal with any technical glitches. So against that background, we thought that it would be well-timed to discuss today a few topics, including why do so many projects end up in disputes, how to approach projects disputes in general, some specific issues when dealing with states or state-owned entities in the construction context, and a few practical considerations when embarking on a new project, particularly in the cross-border context. We want to conclude with a few specific aspects relevant to projects in Romania and in Moldova. And it is my distinct pleasure to be able to cover those topics today with my colleagues Noah Rubins, Erin Miller-Rankin, Gabriel Fusser, Amanda Neal, and Sorin Dolea. And here they are. Just by way of very quick introduction, how it is. Noah is a partner in our international arbitration group, and he heads the international arbitration group in Paris. He also leads the firm CIS and Russia dispute resolution practice. He's an English QC, and he has acted in over 100 arbitrations globally under all major rules, including more than 30 investment treaty cases. He has served as arbitrator in more than 40 cases, including on a number of investment treaty tribunals. He has published widely in the field of arbitration and is a frequent speaker at arbitration conferences across the globe. Erin is a global partner at Freshfields, and she advises on legal strategies and managing risks on major projects. She leads a team of specialist practitioners that work across the world supporting clients on their major capital projects with a focus on emerging markets. Erin has specific expertise of complex international arbitrations in the oil and gas, power, mining, and transportation sectors. She is the co-chair of the Project Execution Subcommittee of the International Bar Association, and she's also one of the co-auditors of the Ultimate Guide to Dealing with Delay and Disruption Claims published last year. Erin also sits as arbitrator in project-related disputes. Amanda, she's a principal associate in our dispute resolution practice based in Vienna. She specializes in international commercial and investment arbitration, focusing on energy, major projects, corporate and financial disputes. She leads large teams in complex multi-jurisdictional arbitrations under a wide variety of arbitration rules. Amanda also sits as an arbitrator in a variety of cases. Gabriel is an associate in Freshfields Arbitration Group in Paris. He specializes on disputes in the energy, mining, and real estate sectors. And prior to joining Freshfields, Gabriel was an associate in the dispute resolution practice of one of the leading law firms in Romania. He is qualified in New York as well as in Romania. Last, but certainly not least, Sorin is the managing attorney at Dolea Co and co-founder of the Moldovan Arbitration Association. He is currently a PhD candidate in international law at Moldova State University, and he holds an LLM in international dispute settlement from Geneva Law School. He practiced arbitration in a number of arbitration hotspots, including Geneva, Vienna, and Frankfurt. He is qualified in the Republic of Moldova. So after these presentations, and just to kick things off, I would like to ask Erin the million-dollar question, which is, why do so many projects end up in disputes?
A cynical person might say lawyers. However, there are actual reasons that you can tell. If we can go to the next slide. So here are some of the key reasons. I mean, every project is different. Every project will have its own unique features. But here are the common things that I've seen in doing nothing but projects disputes for a number of years now. First is ambiguities in the contractual documentation. Now that can be for a number of reasons, either because you say something in the general conditions that doesn't align with the specific conditions or with the specifications. It can also be because the people working on the contract came from one legal tradition, say common law, but the contract is governed by another, such as civil law. So people are bringing to a contract what they think it means, which might be different from what it actually will mean when construed in accordance with the governing law. Employer-imposed changes in design or additional works is another issue, and often that comes in the form of design creep. So by making comments on drawings that go beyond comments, they're actually changes to what you're being required to do. Unrealistic risk allocation is another issue. Often you can get hyperactive legal counsel who want to push all risk onto contractors. That will drive a dispute more than actually protecting an employer. So having a risk allocation that reflects who is best able to manage it or a difference in price makes sense. Failing to properly administer the contract. It never ceases to amaze me how many contract managers you have who don't seem to have actually read the contract. If you haven't read it and you don't know what's required in terms of notifications or split of obligations, it's very hard to administer it. So we always recommend a very thorough project kickoff involving all of the team who will be in charge of delivering the works in accordance with the contract, so that people do have a sense of at least what the key points are. Unforeseen ground conditions, that is always an issue, and it's an issue globally, particularly affects transportation networks, and when you're building things that are first of a kind for an area. So if you're building a rail system somewhere that's never had rail, if you're doing a first mining project and you don't know what lies beneath the surface, that could be an issue. Supply chain difficulties has been one of the key hallmarks of the pandemic. In terms of, lockdowns and restrictions happening at different times in different places, posing a multitude of issues for international projects, where you can be doing a project in the Middle East with a contractor from South America with kit being supplied from China. You have to look at where things are coming from all the time. We expect to see issues in the future as a number of countries trying to pull out of the economic hardship caused by the pandemic increasingly insist on local supply chains, which may not be up to the task, and may result in a number of claims as they try and reframe things with international contractors. So let's talk about the top mistakes that contractors can make. Not following the contract. That often is concomitant with not reading the contract. So contracts, in construction tend to be fairly prescriptive around things like notices. When you have a project manager on site who is trying to maintain a relationship and is banking on the goodwill that they have, they tend to just put the contract to the side. That usually doesn't work out in the end. Overly optimistic schedules. So actually, having a schedule where you've just cut links in order to make it fit in with whatever unreasonable demand you might be faced with. One of the things that we recommend is getting a schedule actually reviewed, not just by the owner, not just submitted by the contractor, but having an independent party look at it and see if it's actually workable as a schedule and if it can actually be analyzed. Because it doesn't help you to get into a dispute and say, well, this schedule is never going to work. You can't figure out where the delays were, where the true critical path was. Unrealistically low profit margins at the outset, that automatically tends to put contractors into a claims mentality, which isn't helpful. Notice, huge thing. And again, this can be very cultural. If you start from the West, like with the States, or even Canada, I would say less so because I am Canadian. It's a very litigious culture. So it's common. It's not viewed as something bad or harmful to be protecting your contractual rights by submitting timely notice. If you go through towards the Far East, it's much more of a face and a relationship and a harmony culture where people don't want to do that because they don't want to set the wrong tone and appear like they're going to be very claims oriented. I think it's fine and understandable to want to keep a relationship, but it's better if there's a commitment made at the outset to administer the contract in accordance with its terms. Then failing to request the right type of decision or instruction in accordance with the contract. So not requiring a variation order if people are putting comments on your drawings that actually will amount to being a change. You need to call that out and say, well, we need a variation instruction. What you're asking us to do is change the contract. Just go to the next slide. Failing to submit supporting documentation to requests for extension of time. So obviously sometimes you have to notify with documentation to follow. It's amazing how often people don't submit the particulars when they have to. And then even the approach to submitting them, especially if you're dealing with audited entities such as major international corporations, or governments, you're going to have to submit some sort of substantiated documentation that makes sense and supports why you get an extension of time. So it has to show where the critical path was. It has to say what happened. It has to show why the consequence of that was because of the thing you are complaining of. Incorrectly valuing claims. So this can either go one way or another. Either people will just look at one narrow part of a claim and forget big money items such as disruption caused by multiple changes. Or they can just throw in a massive number, on a view that it will settle things. And often it can just split things further apart. Acting on variations before you agree time and cost is a significant problem. I mean, sometimes, obviously, you have to if there's some sort of an urgent situation, but you would want to make sure, even if time and cost are not agreed right away, that there's a recognition that it is a variation and that they must be agreed, and that your position is that there's going to be an impact. And with this, you have to take particular care if there's an engineer or an owner who consistently signs off and says, yes, it's a variation, and no matter what it is, even if it's, changed the whole structure, will say no time impact. You need to always protest that and say that is not consistent with what we've agreed and what we are saying, because often people will just robotically write that on every variation. Mitigating disruption and subcontractor delays is another one. Disruption can be really hard. Almost as important as mitigating is properly documenting disruption. But with subcontractors, and when you're managing that fine balance, if you're a main contractor, or even if you're stuck in between a main contractor and a subcontractor, you want to make sure that you're saying consistent things. You shouldn't view the relationships as being watertight, and that you would never be in a position in an arbitration where you would have to disclose documentation, such as if you're telling, the employer that it's all their fault, and then you're also telling your subcontractor that it's all their fault. You could get caught out in playing a game like that. Design changes, which are coming in by stealth. Again, this is the design creep issue, comments on drawings. You should not be willing to act on changes that are not being introduced properly, which usually means in the form of a change order or a variation order, because that machinery is there to give you protection in terms of what you can claim flowing out of it.
And Erin, do you commonly see these issues across projects globally, or are some more specific to particular regions or perhaps particular cultures?
I think where you tend to see it the most is where you have a combination of cultures, right? So if you have a contractor from the Far East working in the Far East, there's a general understanding of culturally what's expected. Similarly, in America, if you have an American contractor working on a contract for an American employer, there's an understanding of how it works. How it can get a bit difficult is if you have international entities importing a view that it's going to be like it is at home. In other contracts. And then you have things where, situations evolve. So it used to be the case in some regions where, you would look at making it up on your next project. There was, less scrutiny over governments. There was less scrutiny globally over issues of corruption. There's a lot more regulatory oversight on projects now. I think that can make it more difficult. And where you see that level of scrutiny, especially if there are, World Bank or other multilateral funding agencies involved, if it's project finance, you have to be a bit more prudent in terms of protecting your right. When other people can look in and decide, have a say in whether or not you get paid, you need to make sure that you've got all of your documents in order.
And staying with you, Erin, what is your advice on how parties involved in projects should approach disputes when they arise, particularly when we move across cultures?
Other than calling good lawyers? Sure, happy to do that. I mean, one of the things about construction disputes is, you have a lot to do after the dispute arises, but your success in that is going to hinge in large part on what you do while the project is on foot. Are you getting your notices? Are you keeping records? Will you be able to show afterward where the crews were working, where the superintendents were, when something was supposed to show up versus when it actually did show up? And your success once you are in a dispute is the importance of having a neutral dispute forum. So it can often be difficult if you're a foreign entity and you're going into a host state court system that isn't yours. You may not understand it as well. And depending on the state, you may not necessarily get a fair hearing. So you would normally want, neutral decision makers, ideally specialist decision makers. There are a lot of courts that will appoint experts. So you could have, I've actually seen a case where there was a court-appointed expert for a complex power plant, and this expert had only ever engineered gardens in public parks. I mean, it was just completely different. He was an expert in building something, nothing like what the subject of the dispute was. You're also going to want to look at the enforceability of awards, including against states. So is it a New York Convention place or not? And a convenient venue. So you can have one kind of governing law, you can have a different procedural law, and you can have a totally different venue. And I think sometimes that's not as well understood. So you should look at whether you are going against a government. Some governments have prohibitions against agreeing to a foreign law or a foreign seat for a dispute, or they might need a special approval for arbitration. You should check that to make sure that you have an enforceable position. You have to look at whether you do have or want to have a long-term relationship, as well as whether you have any overlapping investment treaty protection, because sometimes you may find that that with all the will in the world, you need to resort to that.
And are there specific or more prominent dispute resolution options that you see in construction cases?
Often, if it's project financed, you see UK law, London seat. It just seems to be something that project financiers understand and are quite comfortable with. So that shows up a lot. This slide shows the most common seats. So you have London, you have Paris, Dubai, and Singapore. Rather than being a choice seat of everyone, I think Dubai has had a legacy position there due to just the sheer amount of construction and follow-on disputes that you've seen. But London and Paris are very popular, and if it's not being driven by project finance, in my experience, it's often been driven by the legal tradition of the place that you are doing the project in. So whether it has a common law tradition, people would lean more towards London. Civil law tradition would lead more towards Paris. And Paris, of course, is always popular because it was often because of the ICC rules. And in terms of rules, it's often ICC or LCIA. There are a number of other rules that are becoming increasingly popular. SIAC rules, for example, in Singapore. Hong Kong rules are very good. AAA in the States, but it's still predominantly ICC, LCIA. It seems every jurisdiction wants to get its own domestic arbitration center. I'd be cautious about doing a dispute in a foreign country and necessarily agreeing to their local center. Some of them are frankly not that good.
And when most of those construction contracts, they have multi-tiered dispute resolution provisions that require all kinds of things to happen before one moves to arbitration. So what are your top tips on how to approach those?
On how to approach multi-tier arbitrations?
Yeah.
Well, by following what the contract says you have to in order to get to arbitration. So you need to send your notice, you need to have an amicable settlement period and document that, like send a letter saying, it was great to have that settlement, amicable settlement talk today, too bad it didn't work out. If you need to get an engineer's determination or mediate as a precondition, then you have to do it. Certain courts and national laws take a very strict approach. And even sometimes you can have a clash if you need to get interlocutory relief, for example, get an injunction to stop a bond call, but you haven't met your conditions. You might have to find that you start, and then hold to cover that gap, but you will ultimately have to follow those steps or else you'll face a jurisdictional objection.
I would like to move now to understanding a bit better how you go about choosing the tribunal, and again this theme of being mindful of cultural differences and the tribunal dynamics. Given the specific feature or the specific nature of construction disputes, are there any criteria or things that you recommend parties to take into account when selecting arbitrators?
Well, I think diversity is important. Expertise is important. Efficiency is important, which is why I'm going to speak quickly, as I believe I'm over time. But you would want to have a tribunal that's going to understand the issues the way that you meant them to be understood at the outset. So if you have, a French party and a Spanish party over a project that's governed by Italian law, I don't know why you would get 3 white guys who are QCs from England to hear that dispute. They may have a lot of industry experience, perhaps less in terms of the business culture and the legal culture that would be applicable. So knowledge of the law, language skills, industry, availability, and strong management, because there are so many issues in construction with the volume of paper and the number of witnesses that can be involved that you need people to keep a handle on things.
I know we are running soon shortly on time. I did want to ask one final question about again cultural influences on the dynamics of the tribunal, and what are, in your view, the areas where those cultural aspects can make a difference when tribunals are hearing construction disputes?
Well, I think culturally, especially tribunal members who are coming from a civil code jurisdiction, they will be much more inquisitorial. They will look into the dispute. They will care much more about what the documents say rather than what any witnesses say. They'll be more likely to appoint a tribunal-appointed expert rather than having any time at all for any hired gun experts that you might want to have. And there would be a propensity towards shorter hearings, which would be aligned with shorter court proceedings, as opposed to common law, where it wouldn't seem unusual at all to have a 3 or 4 week hearing and much more emphasis placed on fact witnesses. Although it'll be interesting to see if that changes now that they've done actual scientific reports on how fact witnesses apparently don't really remember much accurately at all.
Okay, Erin, perhaps we can now move to looking at how things may or may not be different when dealing with states or state-owned entities. I would like to cover this topic with Noah. So perhaps we can achieve technically the switch of speakers. And
thank you for my extension of time.
Thank you, Erin, very much.
Hello, everyone.
Hi, Noah.
Hello, Matej.
Thank you for joining us. So as I said, I would like to briefly cover with you how things happen, on what parties should be mindful of when dealing with states or state-owned entities in the context of construction projects. And perhaps just to kick things off, perhaps you can give us an overview of what would be the dispute resolution options for contractors when dealing with states.
Sure. And the first thing to say, or the first question to ask, is why do we focus at all on states in relation to projects disputes? And the answer is, in some parts of the world, for example, in North America, the great majority of disputes or projects are between private parties. It's a private employer and a private contractor and a private subcontractor, and all the way up the chain, it's private to private to private. In many places in the world, and this is not just the developing world or transition economies like Moldova and Romania, but in Western Europe as well, the state is a major employer. It's a major orderer of construction projects, and as a result, particularly the largest projects, infrastructure projects, energy projects, and so on, have a state element to it. Often it's not the state itself, although the state is in the background providing the capital, providing various forms of support. And it's very often a state-owned corporation that's charged with running, managing the project through the means of a private contractor. So, and the question now to the question posed, which is where states are involved. what are the dispute resolution options, and how are they different from a purely private to private situation? Well, for the most part, it's the same thing. That is to say, you're always going to have a contract, quite a complex contract. Sometimes you'll have multiple contracts, but all of them will typically include some form of dispute resolution clause. Now, where it's a cross-border contract, very often that dispute resolution clause will be for international arbitration. It may be for local courts or foreign courts, but of course, as a foreign private party, engaging with a state entity is particularly important to ensure that the contract does provide for an international neutral forum where expertise in the subject matter is guaranteed, and where enforceability across borders and against sovereigns will be simplified. And that is generally international arbitration. So you will have, I hope, an arbitration clause, and therefore whatever disputes arise out of or in relation to that contract should be subject to arbitration, or in the worst case scenario, litigation in the national courts. However, where there is a significant state presence in the project, there may also be the possibility of a claim against the host state under an international investment protection treaty that binds the host state, that is to say the employer, whether directly or indirectly, and the home state of the contractor, of the private contractor. And of course, there is always the possibility of mediation. And I'm often asked, well, what about mediation and conciliation? Should we put a mediation clause in our contract? Should we have a pre-arbitration mediation requirement? That's a whole seminar in itself. My experience is that particularly where state entities are involved, mediation is a very difficult thing to make work, particularly prior to the launching of formal arbitral process. The simple reason is that states are bound by the budgets to which they're bound. Often they're adopted by democratic process through parliamentary action, and in order to allocate money to pay for claims, there has to be a binding judgment. Just coming to a compromise because that's the right thing to do, or in good faith, or for the building of good relationships, is sometimes not productive. It's not possible, actually, practically, from the bureaucratic and democratic process. I once represented a state in a construction-related investment treaty dispute in Eastern Europe, and we told the state that there was exposure probably in the range of 10 million euros, and they might want to just reach out and settle for one. And the state chancellor said to me, "You've really ruined my day." I said, "Why? I'm offering you an inexpensive way out." He said, "I'd rather have a 10 million euro award against me than to settle without one for 1 million euros. For precisely that reason," he said, I wouldn't be able to explain to Parliament why they had to allocate the 1 million euros for the claim. Now, in the end, we actually got the whole thing dismissed. So in the end, he was right and I was wrong.
Can you explain a bit more how those international investment protection treaties work?
Right. Yes, sure. So investment protection treaties have been around for a very long time. They've been around since 1959. And since 1969, these treaties have tended to include arbitration clauses in them, which constitute an open offer to arbitrate qualifying disputes with qualifying investors, even if there's no contract between the state and the investor. These treaties were sort of a dead letter for a long time. Nobody knew about them. Nobody used them. The very first case brought under one of these treaties came in 1987. And you can see from the graph here that the growth in litigation under these treaties has grown, is exponential, such that today we know about over 1,000 investment treaty arbitration cases. 1,000. Right? Many of them settle, There may be more of them we don't know about because some are confidential. But in any event, the way it works is quite simple. State A and State B sign one of these bilateral treaties, or they join into a multilateral treaty that provides for the same thing. In that treaty, the state signatories agree to provide to qualifying investors and investments a certain range of substantive protections. And the most important ones are things like no discrimination, no expropriation without compensation, and fair and equitable treatment, whatever that means. We'll probably come on to it in due course. And if there's an alleged breach of one of those substantive protections, a qualifying investor who has a qualifying investment can launch arbitration directly against the state to seek compensation for the damage resulting from that breach.
So if we were to put this in a sort of diagrammatic way, is it the case that you can have, say, a contractor coming from a third country like the UAE having a project in Romania, and something, or vice versa, a Romanian contractor investing, for instance, in the United Arab Emirates, and something goes wrong, and based on a treaty between Romania and the United Arab Emirates, one or the other may or may not have a claim against the other government. Is that?
Yeah, that's a good summary, and it's important to remember that it goes both ways. And the best example of this is the United States, which for a long time was party to the most used investment treaty in the world at the time, which was the North American Free Trade Agreement, which linked Canada, Mexico, and the United States. And of course, when it was signed in 1993, the American government never even once conceived of the possibility that Canadian investors might sue the United States under these treaties. In fact, that happened again and again and again. In fact, my first investment treaty case that I was involved in there were two in a row against the United States of America. It was a big shock for them. But for you, what it means is if you're a Moldovan investor or Romanian investor, you should remember that your outbound investments may well be covered by one of these treaties. It's not just about suing Moldova or suing Romania.
And that is actually a very interesting point, Noah, because it is true that perhaps the original idea was to structure those treaties to allow investors from developed countries to facilitate their investments in developing countries. And we saw in recent years a wave of claims from investors in developing countries suing some of the natural developed countries, including in Europe, and that led to a sort of a public damnation of the system implemented by those treaties, which is all quite fascinating, I think. It's including at the European level, which may be very relevant for Romania in the context of projects as well. So you've mentioned a number of protections available. Which ones do you think are most relevant in the context of construction projects, or are there some that are more relevant than others?
Well, I think the most relevant ones, first of all, is fair and equitable treatment, because it is so general. I should say one of my first investment treaty cases was against the Russian Federation involving the construction of the new Supreme Court building in Moscow. And there, one of the very important protections was full protection and security, because it was said that the Russians had sent in troops to eject the investor from the Belgian investor from the project when it wanted to take over, and that was said to be a violation of full protection and security. But certainly the observance of obligations clause, also known as an umbrella clause, you can see the black arrow there, is extremely important for project disputes. And that's because, unlike for disputes that arise out of regulatory change, which are probably the most common category of investment treaty disputes, in the project's context, you almost always have a substantial, well drafted contract that has very specific obligations and rights of the parties. And so what the umbrella clause does, ostensibly at least, is it elevates the national law obligations that are contained in the contract to the international level and allow for a treaty claim to be brought on essentially the same factual basis, roughly speaking. There are other protections that are relevant in projects. Free transfer of returns, for example, is quite important because so often it's important that the flows of capital be kept moving during the project in order to ensure the timely delivery of equipment and materials. And where there are, for example, currency controls, import controls, and so on, that can be a real problem. And also expropriation. As I said, there is always a requirement that expropriation, whether it be direct or indirect, be accompanied by full compensation. And one can easily characterize the wrongful termination of a construction contract as an expropriation indirectly of contractual rights.
Perhaps I'm just mindful of time. Perhaps one final question from me is it possible to bring a treaty claim for a simple breach of contract? And if so, what are the main things that one should look at when trying to do so?
So I think the easy answer is yes, you can. But it depends what kind of contract, with whom the contract is, and how it's breached. So not all breaches of contract are going to form at least good treaty claims, and many in the past have been dismissed because they were just too contractual and they were not international enough. And so a lot of times what you will have is contract and treaty arbitrations being conducted in parallel. And for example, we represented for many years the foreign investors in the peace pipeline between Egypt and Israel, which was a huge project that was designed to bring Egyptian gas to the Israeli market. And in 2011, the gas supply was stopped. There was, of course, a gas supply agreement that called for Cairo arbitration, English law. But there was also treaty rights of the foreign shareholders in the company. They said that their interest in the company and in the project had been expropriated. And so we ended up with 4 arbitrations at the same time, 2 under contract and 2 under treaty. Now, how do you know if that's going to work or it's not going to work? Well, the first question is, what's the privity? That is to say, is the claimant company in the treaty arbitration, the investor, has he signed the contract, or is he just a shareholder or another stakeholder in the project, such that the investor would not have a direct right under the contract? Same thing goes for the state. Is the state a direct party to the contract, or is it a state-owned entity that has signed it? And generally speaking, it's hard to say, with any absolute certainty, but generally speaking, the less privity to the contract, the easier the claim gets, because the investor can easily say, you want to send me back to contractual arbitration, but I actually cannot sue the state except under the treaty. And what has happened to me is because of the state as such, and not because of the state-owned company alone. And of course, you also need to look at the dispute resolution clause in the contract. Could it be implied to exclude other rights of recourse? And could it be interpreted to require the treaty tribunal to wait until the contractual forum actually rules whether there's been a breach of contract or not? Now, in most cases where there's treaty claims and contract claims, there are additional problems that have arisen around the edges of the contract where other government agencies, besides the one that signed the contract, have interfered. They've raised taxes, they've changed the regulation, they've created obstacles to timely performance. They've done other things which may not actually be breaches of contract, or they may be independently unfair or expropriatory in the use of state power, aside from the direct contractual relationship between employer and contractor.
No, I think that final point can be the subject of a seminar, of a day-long seminar on its own. But thank you so much for your insights into how all of this works. What I would like to do now is move to a few practical tips and practical considerations about what to do when embarking on a new project, particularly in the context of cross-border projects. And Amanda, I know that you have a few tips for us, so over to you.
Thanks very much, Matej. Yes, exactly. Today I want to tell you about some of the practical matters you need to be aware of when you are engaging in projects work, generally, actually. So if there's one thing that arbitration lawyers know very well, it's that our clients, for the most part, really don't like being involved in disputes, which is totally understandable because disputes are, from a commercial perspective, a huge burden. But they are also, unfortunately, in some cases, inevitable. And Erin told us a little bit about that earlier today. And that might be because an arbitration claim is brought against you and you have to defend yourself. And it may also be because arbitration is, in fact, the best way for you to protect your interests. And so you commence arbitration proceedings as a claimant. But what a lot of people don't know, what a lot of our clients don't know, is that the outcome of an arbitration can be significantly impacted by factors that arise well before the dispute itself arises. And if you have a good understanding of what these factors are, you can have a substantial positive impact on the course and sometimes even on the outcome of a dispute. So on the next slide, we have listed 3 things that you can do to influence the outcome of any dispute that might arise on your project, even before the dispute itself arises. First, you can ensure that you structure your project in a way which enables it to benefit from investment protection treaties in the manner that Noah has just explained. Second, you can ensure that your contractual documentation contains all the provisions necessary to protect your interest to the fullest possible extent. And third, during the course of the project itself, you can put in place systems and processes which ensure that any future arbitration runs smoothly and to minimize nasty surprises. So turning to the first point, which is investment treaty structuring. Now, while you might think this is a very technical matter that requires specialist knowledge, making sure your project is protected under an investment protection treaty is, in fact, relatively straightforward once you know how. Now, remember, as Noah explained, you don't need to be entering into a contract with a state or a state-owned enterprise to benefit from the protections provided by investment protection treaties. Your contracts may be solely with other companies responsible for executing a project, but it's nevertheless prudent to structure your investment in a way which ensures that it is protected under an investment protection treaty, because this will give you the greatest chance of having a remedy in the event that your project is negatively impacted by state action. So in general terms, when engaging in investment treaty structuring, there are 5 key questions that you have to ask. The threshold question is there an investment protection treaty between your home state, that is the state your company is incorporated in, and the host state? Now, say, for example, you're an Italian company. Is there an investment protection treaty between Italy and Romania, or between Italy and Moldova, for that matter? Gabriel and Soren are going to talk about the investment protection treaties Romania and Moldova are party to a little bit later, but spoiler alert, there isn't. So what do you do now? Now, because investment protection treaties apply not only to natural persons, but also to legal persons, this gives you an opportunity to engage in what's sometimes called treaty shopping. Now, provided you're not already in a dispute with a host state, this is generally speaking acceptable. Basically, treaty shopping involves reviewing all of the treaties which the host state is party to, and figuring out which is the best one for your project, and establishing a project company or vehicle in the relevant counterparty jurisdiction. Now, there are there are many important things to keep in mind, but two in particular when selecting your investment protection treaty. First, if your host state is in the European Union, for example, Romania, and your company is incorporated in the European Union too, you'd be well advised to choose a jurisdiction for your project company which is outside of the EU. And there are particular legal reasons for this relating to recent decisions of the European Court of Justice. And the other thing to keep in mind is that investment treaty protection is, of course, not the only thing to keep in mind when you're structuring a project. So be sure not to forget other factors like tax consequences when you're establishing companies in particular jurisdictions and deciding how to structure your project. Now, once you've identified which investment protection treaty you could rely on, you basically need to engage in a comparative exercise to determine which of them will provide you with the highest and best level of protection, and therefore where you should establish your company. Now, the relevant questions that you need to ask are listed up on the slide. First of all, will your project company qualify as an investor under the treaty? Now, there are, again, several things to be aware of, but one I'll mention in particular is that some treaties exclude mere shell companies from the definition of investor, and they require the company to be doing real business in the relevant jurisdiction. The next question you need to ask yourself is, will the project qualify as an investment under the treaty? And one thing to be aware of here is that mere contracts for services or for money, they don't qualify as investments. You really need to be owning, directly or indirectly, some kind of asset, such as shares in a company or real or movable property in the host state. After you've established that you are an investor and you have an investment, you have to consider which of the available treaties provides you with the highest level of protection. And finally, look at which treaty provides the best dispute resolution options. And generally, this will be treaties that provide direct access to exit arbitration, investment arbitration, and without you having to go through the local courts first or waiting too long to commence proceedings.
So, Amanda, if I may.
Sure.
You've mentioned this exercise and the key questions that one needs to answer. When is the idea that should all be done before you set up a new project in a new jurisdiction, or is it acceptable to do it even throughout the life of a project, arguably before a dispute arises, for instance?
Exactly. So the key thing here is to engage in this process before a dispute arises with the host state. Once the dispute has arisen or there's any hint of a dispute arising, it could be considered to be sort of an abusive process. But prior to that, and ideally when you're engaging in the project, you can freely engage in this kind of structuring exercise to maximize your protection under investment protection treaties.
Okay.
So once you've structured your project, the next thing you need to do is negotiate strong protections into your contracts. And the threshold issue here is to be aware of the impact of local law on key areas of the contract. Now, I'm not going to go into this in too much detail because it's going to be covered by Gabriel and Soren a little bit later. The key areas here are to consider statutory obligations on liability for defects, consider the interpretation and enforceability of liquidated damages clauses, to consider limitation of liability clauses, and to consider termination provisions. Once you've gone through that process, there are a few other areas you give particular focus to, and they are force majeure, stabilization clauses, sovereign immunity, and dispute resolution. And I'll just give you a brief summary of each of those, starting with the easiest, which is force majeure. It's relatively popular at the moment as a result of the pandemic. Briefly, a force majeure event is an unforeseen event which occurs outside the control of the parties, and it excuses performance until the event passes. Now, the parties can define specific circumstances that they agree to treat as force majeure events, for example, a pandemic, And it's a very good idea, and we've learned that in the last year, to give careful consideration to what factors these will be and what the specific consequences are. Now, stabilization clauses and sovereign immunity are issues which affect contracts with host states or with governments, as Noah has explained. And a stabilization clause is a clause that addresses how future changes to laws or regulations in the host state will affect contractual rights and obligations of the investor. So it basically allocates risk associated with changes in law and regulation. Now, these kinds of clauses used to be very prevalent in investment agreements and in concession agreements, but states are increasingly less willing to accept them, and ultimately they'll be a matter of negotiation. The other thing to be aware of is that there are limits to what you can do with a stabilization clause, especially in civil law jurisdictions. For example, you can't limit a state's power to ensure that they're protecting public health or security. And in some jurisdictions, they're not valid at all. So in other words, you can include them in your contract, but they might be of limited value. And they may not protect against changes in legislation, but what they might do is impose on the state an obligation to act in good faith and give rise to an obligation to compensate in case of breach. Sovereign immunity is another important factor to consider. It's a rule in international law which precludes the courts of a state from exercising jurisdiction over certain classes of cases in which a sovereign is party. And the rationale is that states should be free to exercise their sovereign powers without undue influence. It operates at two levels. First, it confers protection on the state from being sued in a particular forum. This is immunity from suit. And second, it offers protection from execution of awards against the assets of the state. That's immunity from execution. Now, as a general rule, sovereigns can waive both immunity from suit and immunity from execution. Most states will allow awards or judgments against a foreign sovereign to be executed against assets of the sovereign in the jurisdiction that are used for commercial purposes. But special protection is usually provided for diplomatic property, embassy accounts, military assets, and things of that nature. And the other thing to be aware of is that generally, if a foreign government submits to the jurisdiction of an international tribunal through an arbitration agreement, that very often constitutes waiver from immunity from suit. The final factor that I wanted to raise in relation to contractual protections is dispute resolution clauses. Now, they're very important to get right. Erin explained earlier the importance of having a neutral forum and having the relevant arbitrators with the relevant industry and expertise, the legal expertise, and also the cultural understanding. And special considerations need to be given to the nature of the counterparty, in particular, whether it's a state authority. Here you need to be very careful about the interplay between contractual dispute resolution clauses and the dispute resolution provisions available under investment protection treaties. What you're really aiming for is for that dual protection, to have protection under the contract and to have protection under investment protection treaty. And of course, if you're ever in doubt, then you should call your lawyers.
And there's just one point on that. Is it fair to say that from those five circles, the stabilization clauses and sovereign immunity are particularly important when you're dealing with states, whereas the others are important across the board, even in pure private contract relations?
You're absolutely right, Matej. So the clauses, the red and the purple clauses, you can see there, are very, very important when you're dealing with states, state-owned enterprises. As Noah mentioned earlier, this is extremely important in transition economies, where the state still has a big role in things like building infrastructure and all sorts of projects-related work. So those to be given special consideration when your counterparty is a state or a state entity.
I just pause 1 second because I just remember that I forgot to mention one thing for the viewers at the outset. There is an ability to put questions in the form of comments, which we hopefully will be able to see and address. There is no other option for asking questions. We do plan to have a few minutes at the end for to answer some of the questions or comments. Thank you, Amanda. Sorry for breaking your flow.
No problem at all. So, I mean, the final topic that I want to talk about today is another important topic that Erin mentioned, which is what you can do during the course of your project to ensure that it runs smoothly and that any disputes actually run to the maximum extent possible in your favour. Now, the three factors to consider here are: first, proper document management; second, discipline in creating documents; and third, effective preparation of claims, which basically means being aware when a dispute arises and taking particular care to keep careful records. Now, one thing you'll notice is that all of these factors concern document management. Why are lawyers so keen on proper documentation? Well, from a lawyer's point of view, documents are evidence. And contemporaneous documents are, in fact, the best form of evidence. They are primary evidence. They're better than witness testimony, and they're better than expert testimony in many cases. So documents are the best tool that a lawyer has to help you prove your case or to defend you. And your ability to support a claim may be greatly compromised if you don't have proper documentation. So documents, the other thing to be aware of is they're also the tool which can be used against you by your opponent. Most arbitrations have a process called document production, where your opponent can ask you to hand over documents relevant to the dispute. And you may therefore have to provide your documents, including unfavourable documents, to the other side. Now, a failure to have maintained proper documents might actually result in a tribunal making adverse inferences, perhaps, you know, the idea that you may have destroyed documents, and they could lead to adverse findings against you. So the main takeaway here is that your document management system should be focused on creating good evidence for the future in case something goes wrong. Now, on the next slide, on the right-hand side, we have a very handy list of do's and don'ts. One important thing to keep in mind is that your hard copy documents should be scanned and kept as electronic files. The reason is that documents get lost, and if they have not been contemporaneously scanned, properly archived, you might end up in a dispute 5 or 10 years from now, and you may not be able to find those documents anymore. And that is a disaster for us lawyers. Another factor to keep in mind is that you shouldn't use your personal email address for business purposes, and in fact, ideally shouldn't use text messages or WhatsApp for business purposes, but if you do, keep records of those messages. Never destroy your documents. The reason for that is the one I mentioned before, that might lead a tribunal to making an adverse finding against you. And always file your future evidence properly so that your lawyers can make the best use of it if you end up in a dispute. The very last point that I want to make today on the final slide is that this relates to controlling the flow of documents. So the best way to think of this is that when you control the documents, you control the evidence, and ultimately you have much better control over the dispute. But conversely, when you don't control the flow of documents, you weaken your position in any arbitration. We've listed some of these factors, the factors that contribute to poor document control on the slide. They are failure to deal with issues promptly, or in some cases even at all, failure to correct errors in documents such as minutes of meetings or correspondence, and failure to create documents required by the contract in accordance with the contract. Also essential in controlling the flow of documents is to avoid creating bad documents. And this is because, as I told you, you may have to hand these documents to the other side. And the 3 top tips I want to leave you with in this regard are that you should always ensure that the necessary staff have read and understood the contract. Erin made the point earlier that she's always surprised how many people have never read the contract. Don't be that person. Make sure you understand what you've agreed to with the other side. Never create superfluous documents that are adverse to your position. And finally, stick to the facts. Don't create documents which contain views or opinions, and don't use emotive language in written correspondence.
Amanda, thank you. I will try to control at least the slides today. And while doing that, what I'd like to do is move now to a discussion of more specifically the Romanian and the Moldovan market. And perhaps we will start with Romania. Gabriel, how does all of this work in the context of the Romanian construction sector?
Thank you, Matej. Well, there are a couple of things to mention, and I think first we should begin with some general aspects about the arbitration framework in Romania. And first of all, we should say that Romania does not have a standalone statute on arbitration like some jurisdictions, but nevertheless, there is legislation on arbitration. The Civil Code of Procedure has two separate sections, one on domestic arbitration and the other on international arbitration. And while Romania is not a model law jurisdiction in the sense that it hasn't formally adopted the UNCITRAL model law on arbitration, the general principles are the same. And it's important to note that the section on international arbitration adopts a broad approach to arbitrability of disputes seated in Romania. And there is also a provision that expressly states that states and state-owned entities are not allowed to avail themselves of their own legislation to argue that the dispute is not arbitrable or they don't have capacity to participate in that arbitration dispute. It is also in the Civil Code of Procedure that we'll find the provisions, for example, on enforcement and recognition of foreign arbitral awards. And those provisions are similar but not identical to those of the New York Convention on enforcement and recognition of foreign awards, which actually brings me to the second point on the slide, and that is to say, Romania has been a party to the New York Convention since 1961. Moreover, Romania joined the ICSID Convention in 1975. And perhaps one last general point, which is potentially less known, Romania also has domestic legislation on the stimulation of investments. And that domestic legislation contains a dispute resolution provision that offers investors the option between recourse to national courts, ICSID arbitration, as well as UNCITRAL arbitration. So that would be the general arbitration framework. Moving on now to which arbitral institutions are preferred by Romanian parties, or which sets of rules are used in contracts to which Romanian parties are part. Aaron mentioned earlier that in the construction context, the most used set of rules are the ICC rules. And as we can see on the screen, that is the preferred set of rules for Romanian parties as well. So from that perspective, it is consistent with the larger trend. As we can see, based on ICC's statistics from 2019, which are the most recent ones available, 19 out of 205 parties from the CEE in 2019 were Romanian, which ranks Romania third among countries from the CEE. Now, where Romanian parties depart in their preference for arbitral institutions is that the second most preferred institution seems to be the VIAC and not the LCIA, as is the international trend, and that speaks to the importance of Vienna as an important regional business hub in the area. And at the VIAC, we have the statistics from 2020. We know that 4 out of 31 parties from the CE, SCE, CIS were Romanian. But more than that, you will see on the chart on the right-hand side of the screen, Romania ranked 4th in the overall, by overall number of parties out of not just that region, but the VIAC's entire caseload for 2020. If we can now then move to the Romanian arbitral institutions, the local institutions, by far the one that is most used is the Romanian Chamber of Commerce Court of International Commercial Arbitration, often abbreviated in English, the CICA. And it is becoming increasingly important, perhaps, in the construction sector. And that is because as of January 2018, the government issued a new model public procurement construction contract for works exceeding 5 million euros in value, and that contract contains a SICA dispute resolution provision. So this is a departure from the previous practice of government entities which would enter into such contracts that contained ICC dispute resolution provisions. And perhaps one thing to also note here is that this shift from ICC to SICA arbitration also coincided with a major update of the SICA arbitration rules, which, as you can see on the screen, they now contain a procedure for emergency arbitrator proceedings. They provide for expedited arbitration proceedings for small value claims, and generally an improved framework for multi-party arbitrations, among other things. Now, there also are two other institutions to note. The Bucharest International Arbitration Court, which was recently founded under the auspices of the American Chamber of Commerce in Romania, as well as the Permanent Court of Arbitration of the Romanian German Chamber of Commerce and Industry. And if I can just mention one more aspect with regard to the SICA, it operates with a list of arbitrators. That said, parties are free to nominate arbitrators from outside the list as well. And the list contains many highly regarded national and international practitioners, including our colleague Matei.
Thank you, Gabriel. That's very kind. I guess, do you have any statistics regarding the use of the national arbitration institutions? Are they busy? Do you know what's their case law, and are they dealing in practice with construction disputes?
Well, Matei, let me start backwards with the Permanent Court of International Arbitration of the Romanian German Chamber of Commerce and the BIAC, the Bucharest International Court. I'm not aware of the statistics for these two institutions. As far as I'm aware, there are no statistics publicly available. That said, the BIAC, for example, was only very recently founded, so it wouldn't have had time to have a big caseload at the moment. That doesn't mean that it won't have one in the future. As regards the SICA, we do know that construction disputes are a big part of the cases it administers. And while I don't know, I haven't seen official statistics as far as I'm aware. There are around 100 cases per year, 25% of which are international. And given this change in change in the model public procurement contract for construction works over 5 million in value, we can only assume that construction disputes will continue to play perhaps even a bigger role than they have so far at the SICA.
Okay, thank you. Yeah, I think that's probably right. And as far as I know, I think the numbers you've mentioned are probably consistent with what I've seen in their practice.
Okay, if we can then move to some substantive issues. We have picked what we called six key areas of which international contractors should be aware. Of course, these aren't the only ones. They're just the ones we picked for today's purposes. And they relate to liability for latent defects, liquidated damages, termination, force majeure, legality of stabilization clauses, and waiver of sovereign immunity. Moving on to the first one, and that's liability for latent defects. For this one in particular, I think it is important to know the interplay between what you agreed in the contract and what the governing law of the contract says. As Aaron and Amanda both said, it's very important to know what you have in your contract, which is why here we've provided a parallel between the 2017 FIDIC suite and what Romanian contract law says. Under the 2017 FIDIC suite, there is a defects notification period, which, as the name suggests, is the period in which defects should be notified to the contractor. By default, this is 365 days long, but the parties are free to modify it. They can also extend it by at most 2 years. But once this disputes notification period expires, or once the remedies are taken care of, the liability of the contractor persists. It's just the contractor will be liable for damages and not would not have to actually remedy the defects. And this is where national law comes into play, because it is those limitation periods in the national law that will govern until when the contractor is liable. There is an exception as well in FIDIC for defects relating to plant, but I won't get into the details for that now. And I will move on to what Romanian contract law says. And under Romanian contract law, there is a general statutory guarantee period of 3 years, but parties are free to change this, with one particularly important exception in the construction sector, and that is the law regulating quality in the construction sector provides that certain professionals, such as the designer, the contractor, the supplier of materials, the engineer, they have to guarantee their obligations for a period of 10 years from takeover, as opposed to the 3-year general period. And even more so with regard to structural defects, there is an obligation to guarantee under certain circumstances for the entire lifetime of the construction. And only after these, well, not necessarily only after these guarantee periods expire does the statute of limitation under Romanian contract law start to run. It can also start to run from the date of discovery of the defects if they are within the guarantee period. But if not, there's a backstop date, and that is the statute of limitations starts to run from the end of the guarantee period, and the defects must necessarily have occurred within that guarantee period. So that's about it with regard to liability for latent defects. We should perhaps now move to liquidated damages, which are particularly important in the construction contract context with relation to delay damages. This is pretty straightforward under Romanian law. Liquidated damages provisions are permitted as long as a liquidated damages provision won't be enforced, however, if the obligation has become impossible to fulfill. And courts and tribunals will generally not interfere to reduce the amount of the liquidated damages provision, except if the underlying obligation was partially performed in a way that is beneficial to the obligee, or if the amount is manifestly excessive. Perhaps one thing to note that's interesting here is that courts and tribunals under Romanian law cannot interfere to increase the amount, although, for example, under French law, from which I believe the provision was inspired, that is a possibility. And of course, or perhaps not of course, parties are not allowed under Romanian law to claim more than the amount provided for in the liquidated damages provision. Moving on to the issue of contract termination. Again, it's very important to know what the contract states. Here, it's generally going to be, you're generally going to look at the grounds for termination provided in the contract itself. And under the 2017 FIDIC suite, there are a lot of grounds, both for termination by the employer for contractor default and termination by the employer for convenience, or termination by the contractor for employer default, for example. And I will not get into the details of those now. Perhaps one to mention is the termination by the employer for convenience, which you don't have under general Romanian contract law. And also another thing to mention with regard to this form of termination is that the 2017 FIDIC suite of contracts introduced a provision that entitles the contractor to claim for loss of profits when termination for convenience occurs. And then under Romanian contract law, again, it's pretty straightforward. You have the employer has the possibility to terminate for contractor default when it's impossible to observe takeover deadlines, when work is not carried out as agreed, or when there's a breach of other obligations under contract or statute. The contractor itself can also terminate for employer default. For example, when the employer agrees to provide certain materials or to obtain certain licenses and does not do so. And then there's also a termination for impossibility to perform, And that depends on the extent of the degree of the impossibility. It can either occur automatically or at the request of the obligee. If we can move to the next slide, there are just 3 points that are important and that Amanda also touched on, and that contractors have to keep in mind. Under Romanian law, force majeure is recognized and regulated. It is defined as an external event that is unforeseeable, absolutely invincible, and inevitable. Also interesting is that you have another possible ground for non-performance, which is called an unforeseeable event, or a caz fortuit in Romanian, which has similar effects but does not require events as destructive as those required under force majeure, for example. In terms of legality of stabilization clauses, which were also mentioned by Amanda, they are permitted under Romanian law, and in fact, the Constitutional Court stated in a decision last year that they are widely used in practice, and we know that they are widely used in practice. And in certain sectors, there are legislative provisions that function as stabilization clauses, although they are not stabilization clauses in a contract, but have the same effects. And with relation to waiver of sovereign immunity, there is no regulation on waiver of sovereign immunity in Romania. Romania is a party to the UN Convention, or will be a party once it comes into force, to the UN Convention on jurisdictional immunities of states and their property, but that convention has not yet come into force. That said, it is still important to negotiate waiver of sovereign immunity clauses, because, for example, if a contractor is contracting with a Romanian state-owned entity, then this will come into play if that contractor, after obtaining an award, then tries to enforce in other jurisdictions where there may likely be a regulation on sovereign immunity and a waiver is required. And in fact, that's something at Freshfields we frequently assist clients at the enforcement stage, including with regard to asset tracing, teaming up with intelligence firms to identify assets in which state-owned entities or any parties have, in which jurisdictions they have assets.
Gabriel, perhaps very quickly, does Romania have a lot of BITs, and are they used in practice, including in the project sphere?
Well, Matei, yes, Romania does have a fair number of BITs, I would say. Currently, there are 76 in force, as per data available on the United Nations Commission's on Trade website. Some of this have been used for construction, for project disputes, as we know, and we will come to that in a bit. In addition to Romania's BITs, Romania is also a party to the Energy Charter Treaty, which, as we know, also provides for investment arbitration, and Romania has been a party since 1998. You will see that some of these are colored in yellow on the screen, and those are intra-EU BITs. Amanda touched on the fact that there have been several developments which would suggest that it's better to structure your investment to be able to avail yourself of a BIT other than an intra-EU BIT. Just briefly, these probably will be terminated soon. Romania has taken steps to approve the process to start terminating its intra-EU BITs, and most of the EU countries have also signed a treaty terminating the intra-EU BITs between them once it is ratified.
Gabriel, just being aware of time, I think why don't we move now to see how things stand in Moldova, and perhaps Sorin can assist us with the general overview of how the Moldovan arbitration framework and the construction sector look like. Gabriel, thank you so much.
Thank you, Matej.
All right. Sorin, can we see Sorin? Perhaps not. Well, I will use this opportunity then to just speak very quickly on a question that we received by not through the comments, by through email. And the question is, are there any examples of claims by investors from Romania or Moldova against other states under investment protection treaties? That's actually a very good question. I think the short answer is yes. As far as I am aware, there is one. Interestingly enough, it is by a dual Moldovan-Romanian national, so again, very on point for today's presentation, and in relation to a project. So it's a claim under the Energy Charter Treaty brought against Kazakhstan by, as I said, dual Romanian Moldovan nationals, and it relates to an oil and gas project in Kazakhstan. Now we have Sorin, so maybe we can jump to Sorin and to an overview of how things look in Moldova.
Thanks, Matej. Hello, everyone. So, besides the common claimant in investment arbitration, we have many common features with Romanian legal framework. But what is different, though, is that Moldova is a model law jurisdiction. So, in Moldova, the lex arbitri is the law on arbitration and the law on international commercial arbitration, which are applicable to all arbitrations situated in Moldova. Of course, there are other provisions from other laws, such as Civil Code of Procedure, Labor Code, Law on Competition, which are also relevant for arbitrations. Moldova is party to New York Convention since 1998 and a party to ICSID Convention since 2011. Now, moving to arbitrability, even though Moldova is a model law country, there are some features regarding the arbitrability of construction-related disputes, which we can see on the next slide. So generally, all the construction-related disputes are arbitrable, except disputes related to residential real estate, including rental of residential properties, disputes concerning public relationship, disputes related to the disposal of public property, except the disputes arising out of any form of public-private partnerships. And lastly, the disputes with foreign element concerning the right of ownership over a real estate located in Moldova fall under exclusive competence of Moldovan courts. Now, talking briefly about main arbitral institutions, in Moldova there are many arbitral institutions, but two of them are the most active. The first one is Chisinau International Court of Commercial Arbitration, which it was founded 3 years ago, 4 years ago almost. It has more sophisticated rules, such as emergency arbitrator, expedited procedure. On the other side, the International Commercial Arbitration Court under the Chamber of Commerce and Industry is the oldest one in Moldova. It has more than 70 arbitrators on the list. It has more experience, and for instance, in 2020, there were 128 cases under its administration. So the arbitration users in Moldova have some decent options in terms of arbitral institutions. Now, moving to key areas where Moldovan law may affect the contract, there are 6 key areas, starting with liability for latent defects. Now, in Moldova, the general guarantee period for liability of latent defects, which we can see on the next slide, is 5 years from the handover of the construction. So the contractor is liable for latent defects discovered within the 5 years period. Additionally, the statute of limitation for latent defects is 3 years from the date when the latent defect is discovered or should have been discovered. Now, moving to availability of liquidated damages, the provisions are quite similar as in Romania, so we will not stop here too much. And we will move to the third aspect, which is contract termination. So, under Moldovan law, both contractor and, of course, employer have the right to terminate on particular grounds. Even though the contractor has the right to terminate on various bases, for instance, employer does not replace the unusable or unqualified material, or employer does not change the instructions regarding the execution of construction. Well, there are a few grounds which we can see in the civil code, in the particular laws, where there's governed the rights and obligations of both parties. Now, the interesting part, which is the last three key areas, stabilization clauses, force majeure, and waiver of sovereign immunity. Stabilization clauses are not expressly recognized and governed by Moldovan law. However, certain laws contain guarantees for investors which have the effect of stabilization clauses. Now, these provisions basically freeze the state's policy applicable to a particular industry. One of the examples is renewable sector, where, according to the law on renewables, the state guarantees feed-in tariffs for a particular period of time. Now, moving to force majeure, it is regulated and permitted under Moldovan law, but unlike in Romania, the force majeure is merged with so-called cazul fortuit under the single concept named excuse due to an impediment. So, Moldovan lawmaker was inspired from UNIDROIT principles and Article 79 of the CASG, and this concept is quite common in international commerce. Now, talking about waiver sovereign immunity, well, Moldova does not have any particular regulation and is not a party to UN Convention on Jurisdictional Immunities. On the other side, Moldova is a party to Vienna Convention on Diplomatic Relations, which governs the immunity of diplomatic assets. Now, turning to international investment protection, so Moldova is a party to 45 bilateral investment treaties, out of which 39 are in force. Additionally, investors need to be aware that only 9 bilateral investment treaties contain umbrella clauses discussed previously. Up to date, Moldova has been involved in 12 investment arbitration cases. 11 are concluded and 1 is pending. Out of these 12 cases, 2 cases concern or are related to construction projects. The first case, which is still pending, is Comaxavia and concerns a dispute under a concession agreement under which the investor has the obligation of reconstruction of Chișinău Airport. The second one is Arif against Moldova, which is the first case involving our country, concerning construction and operation of a number of duty-free stores by investors. Now, there is one particular aspect which is relevant specifically to Moldova, related to territorial scope. Now, naturally, all bilateral investment treaties require the investors to make their investments in the territory of the host country. Now, an important matter that investors might want to learn is whether the investments made in a particular territory of Moldova, which is a region called Transnistria, are protected by the international investment agreements concluded by Moldova. Most of the BATs concluded by our country define the territory as a land over which the state exercises jurisdiction or sovereign rights according to international and national laws. So under international and national laws, Transnistria is a part of Moldova. However, on the ratification of the ICSID Convention in 2011, Moldova notified the World Bank that the convention applies only on the territory effectively controlled by the authorities of Moldova. Now, whether Moldova exercises jurisdiction over Transnistria is still discussable, although there is no case law in investment arbitration discussing the status of this region. In some cases, the European Court of Human Rights found that Moldova does not exercise effective control of the territory in Transnistria, and it does not exercise the authority over that region. So the foreign investors, when investing in this area, might want to be cautious and to do a little bit of research in order to determine whether and to which degree the investment treaties concluded by Moldova can protect those investments. I guess having said that, I'll pass the floor to Matei.
Sorin, thank you so much. That was very helpful. I think I'm conscious that we are running out of time, so perhaps we can deal with a few of the questions that we've received. One, I think, is probably for you, Sorin, which is, are there any specific national laws covering foreign investments and foreign investment protection in Moldova?
Mm-hmm. Well, there is a law actually in force since 2004 called Law on Investments in Entrepreneurial Activity, which it has some standards of protection like guarantees against unlawful expropriation or FAT or standards similar to bilateral investment treaties. But that law, so the ISDS clause in that law provides that the disputes between investors and the host state will be settled by the local courts or by arbitration after the dispute has arisen. So even though the law exists, up to date, I'm not aware of any investor relying only on that law when searching for opportunities to protect their investments.
And a final question is, what areas substantively are most different and relevant between civil law and common law relevant to construction? I'm happy to deal with that quickly. That's a very broad question. I think the starting point probably is contractor in particular or international contractors should be aware that in civil law countries you do have quite a bit regulated by the civil code, and that's in a way that's your starting point. So there are specific areas such as specific performance, for instance, which both Sorin and Gabriel touched upon, that operate differently, and that's why there's perhaps a disparity between what the FIDIC form of contractors of contracts provide in terms of a defects notification period and the general way in which Romanian law and Moldovan law, both civil law countries, approach the issue of defects and liability for defects. Other areas are force majeure, which again is something that is regulated in civil law countries, including Romania and Moldova, as Sorin and Gabriel mentioned. The way good faith operates and what is expected of the parties in terms of contractual performance, as well as specific statutory termination rights that exist under the civil code and can operate in addition to what parties agreed in the contracts, as well as the role and admissibility, for instance, of pre-contract negotiation. So those are just a few areas that I think are relevant.
I was just away for a second, Matei, did you mention good faith?
Very briefly, Noah, just as a general concept.
I think it's just one area that many people who come from other legal traditions find surprising in the English law, which does apply to many contracts around the world, is that good faith plays a rather minimal role in contractual relationships. That may be a little bit of an understatement, actually. It is the very rare case where an international tribunal or a court will find there to be a duty of good faith where one is not designated in the contract. It may sound strange to you even to think of putting a good faith obligation in a contract. Like, well, of course, because Article 1 of most civil codes in civil law countries is the parties will carry out their obligations under a contract in good faith. That does not exist as a background matter in English law. And so if you really need there to be such an obligation of good faith dealing, you'll want to include that in your contract if English law is applicable, and English law will uphold such a provision. That is to say, if it's in there, then it's an obligation of the contract. If it's not in there, then it's not.
All right. Well, with that, I would like to first thank Erin, Noah, Amanda, Gabrielle, and Sorin for their contributions today, and a really insightful discussion. And then also to Juridice Moldova and Juridice Romania, sorry, for organizing and taking care of all the technical aspects of this webinar. And of course, thank you.
By the way, Matej, we've got 5 minutes, and there are 2 questions that have just now come up from people from the floor. So maybe we address those.
Oh, sorry. Yes. So the first that I see comes from Smaranda Miron. Is mediation before arbitration happening in practice in Moldova and Romania, or would you say the tendency is to go straight before arbitrators?
Maybe. Yeah, maybe Sorin has a sense in Moldova what the practice is. You're on mute, Sorin.
So, Matej, can you briefly restate the question, please?
Sure. Is mediation before arbitration happening in practice in Moldova and Romania? Or
Well,
would you
yeah. In the law, mediation is practiced more in non-commercial disputes, although I mean, in the recent years, these practices have been promoted. So, I mean, in practice, it happens, but not as much as we would like it to be.
Gabriel, any thoughts on how that compares to what's going on in Romania?
I think the situation is somewhat similar, and perhaps you have some ideas here as well, Matej. But there was, as far as I remember, there was a trend at some point a few years back to promote mediation, but I think in recent years that has toned down a bit. So perhaps parties still tend to go to arbitration more than to mediation, and then arbitration or only mediation. Although there was a push to promote mediation at some point a few years back.
I think that's right, and I think one also needs to look at what contracts, such as FIDIC, for instance, provide in terms of multi-tiered resolution clauses, where, although not formally mediation, you have a variety of ADR systems and mechanisms that should happen before you go to arbitration. The other question is, what are states doing to protect against an increase in dispute settlements? Is there a trend to negotiate or terminate DITs by states?
So I'm happy to take that in the first instance. Yeah, I think the most important thing that's happening is that states around the world are changing the terms of investment treaties. They are narrowing their scope. They're imposing certain limitations on the substantive protections. They're putting footnotes and glosses and explanations that are supposed to exclude the outliers, that are supposed to make really only the most serious disputes go to arbitration. Now, there are some places in the world where states are also terminating BITs both unilaterally and bilaterally. Most importantly, the European Union has now insisted that all of its members terminate all of the treaties between them, but there are other states that are doing it unilaterally, particularly places like Venezuela and Ecuador, who have been the subject of many, many, many investment treaty cases. But that's really the outlying area. I think there's a general sense that investment treaties are important to investment flows. Everybody wants investment flows, but there's a desire to reduce the number of disputes, and particularly the number of disputes, for example, that deal with health issues, public emergencies, and these sorts of things.
I think I would add to that, Noah, the case of India, which I think a few years back had a similar wide-ranging initiative to terminate its BITs and negotiate new ones on a new model. I don't think that went very far, but a large majority of BITs that India signed were put to an end. Okay. Well, thank you again, everyone. Thank you, Juridice, and thank you all the viewers who watched us. We hope that you found the discussions useful and helpful, and have a nice evening. Goodbye.
Thank you.